ticket.
On Saturday evening, Djokovic's legal team uploaded their 35-page submission outline to the Federal Circuit Court of Australia ahead of Monday's hearing. It revealed Djokovic had certified evidence that he tested positive to COVID in mid-December, which was submitted with numerous other documents when applying for a visa. To talk about how Monday's court hearing might unfold, I spoke to accredited specialist in immigration law, Farid Varess.
Submissions show that the ground for the cancellation was that the risk to health, safety and good order of the Australian community, or a segment thereof, that was the basis of the cancellation. Of course, Mr. Djokovic is reportedly not taken the COVID-19 vaccine, but even so, given the prevalence of COVID-19 in Australia, with there being more than 380,000 cases as of yesterday, can it really be said that one additional unvaccinated person would pose a risk to the health, safety and good order of the wider community? And Mr. Djokovic's position is that his strongest argument is that the delegate, in making the decision, mixed up the risk to health, safety and good order ground with another cancellation ground relating to the provision of incorrect information. The ground that attracts me the most out of what he's running is the one relating to medical contraindication. Of course, this cancellation decision is all about a mode of implementing Australia's travel restriction regime. A person holding a 408 visa like that held by Mr. Djokovic, they can travel to Australia without the need for a travel restriction exemption, provided one, they are fully vaccinated, or two, they've got acceptable proof that they can't be vaccinated for medical reasons. That is a medical contraindication for COVID-19. Now, immigration's website, it notes that this is a matter for airline staff to ensure that a person travelling to Australia has a travel exemption or doesn't require one. Indeed, his submissions show that the delegate that cancelled his visa considered that his prior infection for COVID-19 was not a sufficient medical contraindication, acceptable medical contraindication. A bit of an interesting thing that comes out from the submissions is that it appears that in the early hours of around 5 o'clock in the morning, Mr. Djokovic asked the delegate, the decision maker charged with deciding whether or not to cancel his visa, to give him some additional time until 8 o'clock, 8:30 in the morning, to be able to make contact with Tennis Australia and or his lawyers, so that to discuss with them prior to completing his response to the delegate as to why his visa shouldn't be cancelled. And it appears that he was given that additional time, a bed was made up and he was given some time to rest, but that then subsequently supervisors woke him, and he says that in a mischievous way convinced him to change his mind and proceed to a decision without the benefit of having a consultation with his lawyers and or a discussion with Tennis Australia. Now, he says that if he had had that opportunity, there are certain additional things that he would have said, which may have convinced the delegate that his visa shouldn't be cancelled. There is a chance that even if Mr. Djokovic is successful, the decision may not come soon enough to allow him to compete. These are probably the first time that a court's looking closely at the inward travel restrictions that Australia has in place, and it may well want to take its time in making that decision. So yes, all the eyes will be on the virtual courtroom at the Federal Circuit Court of Australia, see if he can progress to the other court, Rod Laver Arena, or not.
Farid Varess, thank you very much for your time.